Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now, it's always a privilege to review the book that I'm going to look at today, and it's the Green Book over there. I've reviewed this book over the years. I remember it from my early days in practice, my time as a student at bar school, when I actually bought my original, what was in those days, the county court practice, which gives you an idea of how old I am. But it's always been a favourite of mine for a lot of reasons. What I like about it, and I'm not making any criticisms of its competitors, all of them have their own wonderful attributes. The Green Book is particularly good for me. I like it. The White Book has it's the ultimate because it's got everything. That's the theory. It does get out of date, as they all do. Then you've got Black Stones, you've got the Brown Book and so forth. And then of course we have the specialist guides like the procedure books like the Family Court Procedure and so forth. Now, having said all of that, why do I like the Green Book, and what is our view, having looked at it and reviewed it over many years? Now, the book, as you probably know, it's in two main volumes with two subsidiary volumes to go with it, and in addition there is the CD, and then you've got, in addition to that, the regular civil court news updates, which tells you about what's happening and the changes that have taken place, which is again extremely helpful. This came out in May 2015, it's issue 1. Can I just say that I'm recording this in June 2015. The Green Book has been out for a few months now, for 2015, but of course it's what I see when I go into court. And in very recent cases that I've had, I've been able to use both the CD and the main book itself, because when I've gone into court, it hasn't been the White Book, it's been the Green Book in the county court that the judge actually has on his or her table when we go in. And it's nice to know that they've got this particular book, because it is actually more up to date than its main competitor, the White Book, which is the old rules of the Supreme Court. Now, the Civil Court Practice, as I say, for 2015 has got the 4 volumes. The general editors are P.K.J. Thompson and Louise de Mambro, and it comes from LexisNexis, and we've given it a title for our review. If you're in civil practice, you need the Green Book, now in a new edition for 2015, and frankly you do. I think whatever type of work you do, if you are an advocate, you should be familiar with how to use both the Green Book and the White Book in some detail, because clearly the commentaries that are in it are the things that are the most important. There's such a lot of information. It's where the law and the procedure are. The idea, of course, that ignorantia juris non excusat is still around is nonsense, because there's no way that you can possibly understand everything that's in this book. But at least it's set out as clearly as it might be. And getting to know how to use it is an important point. What I'm going to do with this review is I will read the review out in general terms and do the presentation. I want to show the actual book first, its various sections. You've got some shading area there which shows you what you might be looking for. This is all the CPR, and at the back you've then got protocols. Then you've got the old Supreme Court rules as they were at the back in the other bit of shaded area for volume 1, and this is volume 1. There's the front of it, and let me just put that in there for a minute, and there is the spine. You can see all the people involved. Let me just show you, obviously inside the inside front cover you've got a lot of information very quickly available, which is very helpful. Then you've got calendars at the back. Now, what have we got in the book? And I'm starting at the front. Well, you've again got a bit of an overlap with key references, again there. Then you've got the actual front page itself. These are the people involved. This is the rogues gallery of people involved in this book. I mean that in the nicest way possible, because frankly I think they're wonderful producing this stuff. It's very difficult to understand. Now, the preface. Mr. Thompson has come up with the usual statements, the rising price of access to justice, and then he explains a few things. Part 36 in particular features very heavily, of course. Recast judgments regulations, then various other notes which we've got. And he's also said something which I think is very important. We'd like to hear from our readers. Well, you're going to hear from us in the sense that we're going to say that we think this is an excellent book. If you want to make a particular comment, there's a name of a person, Rebecca Forster, who's the senior editor, who actually will take on board any comments. Then you've got the various contents for volume 1, very simple contents, and volume 2. Then you've got the special jurisdiction. I'm going to show you the other parts in a minute. Then you've got how to use this book, basically. And it's useful to know because it shows you the layout, it tells you what you've got for the 2 volumes, plus the extra stuff, which I will mention, the other 2 volumes. It's then got a number of things, abbreviations that are used. Again, quite useful. Once you get used to it, it's fine. By the way, the paper's very thin because there's so much. There is index to paging and cross-references, of course. Then you've got developments since October 2014 with reissue. Because what happens is the book is issued, has happened again recently with the Court of Protection practice. As soon as they do that, then they introduce the rules afterwards. So you've then got to try to cross-refer between the rules you've got and the actual practice volume. But they try their best, and this is the best we can come up with, frankly, at the moment. Then you've got the various updates, practice directions. To say it's become really complex is an understatement. And I just question how long this is going to continue before we then have to start saying, just a minute, how far are we going with this? Because it is getting a bit out of hand, frankly, in my opinion. Not that my opinion counts. There's the information about developments since 2014. Again, there's a lot of stuff, in particular CPR numbers, so the actual parts. So if there's a particular issue you've got, you may want to look here quickly to see, depending on what part number you're looking at, what might need to be done. Then there's a table of the procedural rules there, very detailed. Then very substantial contents all the way through. And then we start off right at the beginning with the first of the CPR numbers. Let me just show you so you've got some idea. There we go, civil procedure rules, front bit there. And you've got rule number 1, civil procedure rules and so on. It goes all the way through. And you've got, of course, the nice shaded box areas. Quite useful, again, with this particular publication. You do, of course, have the very substantial scope of any rule. Then you've got, after that, the application of the particular rule of the part, and a lot of other information that goes with it, and the cross-referencing, of course, to the practice directions. For instance, let's look at part 36, office to settle. There we go, you've got all of that detail there. And then, right, you're straight into the rules themselves, the rule itself, or sorry, let me rephrase that, the part itself, which is part 36 of the CPR, office to settle. Then you've got, again, the box, the shaded areas, which are the actual rules as amended. They've tried to change it as much as they can to keep it as up to date as possible. Then there are lots of additional points which are included, which are of help to both the advocate and, of course, the judiciary. And then, of course, we run all the way forward. That is volume 1. Now, volume 2, just again for those who are not familiar with this publication, volume 2, there it is. That and that. You've got a lot of shaded areas there because guess what's in volume 2? You've got that, which is quite useful, which is a little flap with some basic information. Again, you've got some useful ribbon here to find things quickly, but you've of course got all the legislation. Obviously everything that's relevant. The Equality Act, particularly interesting at the moment, and how it acts with regard to every single area as a consolidating act. And you've got things like the Mental Capacity Act and so forth running all the way through. Then right at the back, access to health records and so forth. And what you've got on the side, as I say, is you've got all the shaded areas. So you should be able to find things pretty quickly. What you have got again at the back is an index. There is an index which is freely available. The index is very important, it's very substantial. I didn't show you it in volume 1, but it's there. I'll show you that in a minute again. But as I say, volume 2, it again has on the inside cover all the basic CPR numbers, the part numbers, and where you can find them quickly. So a lot of cross-reference, and there's quite a bit of repetition which you need because you've got to know your way around. Then you've got the content section again there, and then we launch straight into the table of statutes and SIs, and then the cases, huge number of cases of course, and then you get into the main. There we go, we start with the Senior Courts Act 1981, and we run all the way through, as I say, to the back with the index. So that's volume 2. Volume 1, let me just show you that again. I didn't show you the index, but there again, the index is basically the same. It's at the back, and it's a very detailed index. You can see that from what you've got. And as I say, right at the back, you've got Judicial Committee rules, and you've got a lot of the practice directions which are linked in. And it is very much a matter of getting used to knowing how to use these documents. Now, we've got Procedure and Guidance. This is the next volume. Again, shaded areas there. And what you've got here are the procedural tables. And then in addition to that, you've got the Civil Procedure Rule part numbers again. And then you've got the various guides. This is the Admiralty and Commercial Courts Guide. Then you've got various other ones. The Chancery Guide, which is a favourite for many people to know how to use it. I've certainly found it very interesting to read. The Patents Court Guide, not something I've really looked at much. Then you've got the Queen's Bench Guide, of course, there in some detail. Right at the back, you've got fees. Now, this statement on fees is very important, but you've got to be aware of any changes that take place. But you should be able to find quite a lot, notwithstanding cross-reference to things like Part 45 on fixed fees. You should be able to find most of what you're looking for with the fees there. And finally, forms. There we go. Now, forms, again, you can get these forms from Google, from the internet. But again, they're useful if you want to print something, a particular form out. You've got the form number, which is there, and you've got the detail. And they're basically all the forms that you need. You've also got things like useful addresses, or the court addresses, for instance, district registries, county courts. You've got all these other specialist type forms, and so forth. And at the front, of course, you've got the list, the introduction, how to use the forms themselves, and then the table of contents listing all the way through, huge number there. Then the N forms, it starts off with the N forms, which is the standard CPR Part 7 claim form. So there we are, that's the claim form side, the forms side. Don't forget the civil court practice itself, which is important to bear in mind. And as I've indicated before, the civil court news. Now finally, let me just say what we think about the book. It's not a long review, this, but the 4 volumes, this is a substantial work. It's the most important document, which everybody who is in practice must know a little bit about. You've got to know how to use it. I think if you are a student, do have a look at this review in some detail and then get used to using the particular volumes so you know what you're looking for. This is what we say, though, whether you're practicing in the High Court or County Court, you'll need the Civil Court Practice 2015, which is known as the Green Book. It was published by LexisNexis, as I've indicated, and it's an essential foremost guide to bringing, defending and appealing civil proceedings. As the standard reference to which judges almost invariably refer in the civil courts, it provides focused, authoritative and comprehensive coverage of the civil procedure rules from a range of experts, and these are the top people in their field. They include judges, masters and leading practitioners, and it's fully cross-referenced to Butterworths Civil Court Precedents, which is useful to know about. It's known for its clear, comprehensive and pertinent explanation of the rules, and the Green Book provides detailed coverage which, as most practitioners agree, is the premier publication, unrivalled by other texts on civil procedure. Obviously I'm mentioning the White Book as well, but these two come hand in hand. All this and the inclusion of numerous case examples and their application place the Green Book, in our view, firmly at the top of the litigation tree. And as I've said, I'm not making any comments. You can't really compare the two because we have to use both. and it depends very much on what you're doing. I personally like the Green Book because that's what I've been sort of brought up with, if you like, because I have a predominantly county court practice. However, it may be if you've done a very large amount of High Court, Supreme Court matters, you might feel more at home with the White Book. All the information you can need, therefore, is contained in the two main volumes, and nothing has been archived. It's formidable as a series of volumes, as I'm sure you can see, but it's quite easy to work through as a reference point. And if nothing, it's very authoritative, and it presents in the four formats an excellent source for whatever you've got a question on. You can use the book, both the CD and there's the e-book as well, and online as part of the civil procedure menu. It used to be that the Green Book, of course, was published every few years. Now, because of the frequent occurrence of massive and significant changes to the law itself and to CPR, it's produced annually, which I welcome. And in addition to the reference facilities it provides, as mentioned above, it also comes with this Civil Court News, which again is, I think, very helpful because it does keep you up to date with any changes that may have occurred. It's a bit like the Nota Upper, which you also get, which Thomson Reuters produce for their version, but I still think it's extremely helpful for us because it's supplied throughout the actual practice year, if I can put it that way, and then we get the new edition coming out round about sort of Easter time next year. Now, all this, of course, means that the Green Book and or its supplements can be with you whenever and wherever you need them. So when you get the Green Book, you're getting not just a book but effectively a service as well. And the latest edition, of course, includes all the most recent updates to CPR. That includes things like the Civil Procedure Amendment number 7 rules, various statutory instruments and so forth. Other new developments include the practice direction updates, which we've got, the 76, 77, 78. They are mentioned at the front of volume 1, if you're looking to find them, and new cases in their context, together with the various legislative consequences. There's also a note on the new developments concerning fees, which, as I say, are mentioned again in the back of this volume here, the third one I looked at. And I think they're all most welcome for any advocate who's got a query, because it's quite possible that the judge is not going to know and you're going to be expected to assist the court. And that's really why you've got to know your way around the book itself. The Procedure and Guidance Supplement is a handbook, that's over there, which you as a practitioner can conveniently and confidently turn to for practical guidance on claims, appeals, applications and so forth. And bearing in mind the reduction in the availability of legal aid and the resulting increase in litigants in person, and there's been a huge increase, frankly, it's worth noting that the form supplement is very useful and user-friendly. It's that one there. It's not that difficult once you understand what you're doing. Obviously, one of the biggest problems that I find with the client, the prospective client, the public access client, is the fact they're afraid. And frankly, you look at this, it's not surprising because it's so terrifying to look at what you've really got to know about. But I think you'll find that the judiciary, they may look all gruff and strong and stroppy and everything, but they equally don't know their way around. So there is a certain amount of latitude within reason so that we can establish, if we don't know what we're doing, we have the time to find what we're doing. And I've been given that by the judiciary. The judges have allowed me time when we've had a problem so I can address the judge. And by the way, at the same time, he can check it up too, so he can make a decision, or she can make a decision, based on hearing me and my opponent on any particular submissions we're making. So I do think that helps. And in fact, the Edison publishers have stated that setting out all the forms in a single volume assists practitioners and litigants alike. That's this one here. And I think that is right. It does help, because everything is done very logically. Typical English fashion, of course, but it's the common law. Effectively, that's what we've got here, and that's how we go about our business. And it's interesting to quote only one small but indicative example from this particular volume we've got. Section 8 of the guidance notes on completing the respondent's notice asks what turns out to be one of the toughest questions for the bemused client, namely, what decision are you asking the court to make? In this forms, okay. Although a difficult question for the litigant, it is at least one comprehensible rather, thanks to the clarity and helpful tone which generally characterises this distinguished publication. Well, I have to say that, don't I? But the point I'm making is that at the end of the day, the very basic questions are properly asked, because quite often you go in and you've got to work out exactly, well, what is it you really want? Because when the client comes to see you, they're going to be in a bit of a mess sometimes. So you've got to try very carefully and deftly to identify what it is they want. Finally, quote, "We're pretty proud of it," the publishers said to us. "We just wish more people realise how good the content is." Well, we do. That's why we've done the review. Our editor and author team have been fantastic at making sure we are as up-to-date as possible. And thank you, you have, because actually this is more up-to-date at the moment than the White Book. As I said, I wasn't going to make any comments about the White Book, but the fact is when it came out it was more up to date. And then you will find then there's the Brown Book that comes from Jordan's and so on. So it's an ever-ending tide, if you like, a sort of ebbing and flowing. Anyway, let me finalise our views on this by saying that considering the ever-increasing amount of legal material the civil practitioner has to assimilate, the Green Book, together with its ancillary services, functions admirably as a friend in need and in court, which does make it an essential purchase for all who practice in the civil courts. I've said before, you're going to see this if you go into court, whether it's the big court with a judge sitting up there or whether we're all on the same level, you're going to see this book and you're going to see possibly it open. There's volume 2. Let me just show you again volume 1 very quickly. Not going to go through any of the others, but just to show you, there it is. It's a heavy book, each one. The pages, I don't know how many pages we've actually got. Well over 3,000. And you've got a huge amount of information here. Just going, for instance, table of practice directions. Again, it really has grown like Topsy, and I don't mean that in any really rude way, but I would say things have really got it's expanded so much then, and I just wonder when we're going to call a halt to it all. I have to say that. But you then start writing with the civil procedure rules at the beginning. Do read, and I think it's every year it's worth doing, do read what is in the preface so that you know what Thompson and his team are. There we go, he's the general editor down there. What Thompson and his team are trying to produce, and how up to date they're trying to get this book, because they're trying their best, and I think they've achieved the almost incredible, almost unachievable achievement. That sounds a little bit of a contradiction, but they've gone that extra mile for us and given us a really excellent service, which means at the end of the day you should be able to find what you want. And as long as the judge is reasonable, you've got to have a little bit of time sometimes to try to assimilate and find what it is you're after. But hopefully you will. Thank you anyway. A big thank you to all the people involved. There are a lot of people involved in this each year. We can't do our business in a democracy without having this sort of thing available and free and relatively straightforward and understandable. It's not that difficult to understand. Now, if you go into other jurisdictions, you may find it rather more difficult. And obviously they don't do things in the same way as we do. But we have the greatest system in the world, the common law. It's the greatest system we've ever seen in terms of law. And long may it remain that way. But we need this sort of publication as well. So thank you to all concerned. Especially also a final word to LexisNexis, Butterworths, for maintaining the mantle of producing this stuff regularly for us. We couldn't do without it. Thank you to all concerned. And good luck with your cases. Bye-bye.